Immigration attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments. Hi there, Dev Move. It's nice to see you. Go ahead, put your questions in the comments now. And then as soon as I'm finished with what I'm talking about, I'm going to go ahead and answer your questions. It can be anything that's immigration related. I'll be happy to answer those questions for you. Now, my topic today is, well, rather, it's a question that I'm going to answer. And is a relative or spouse threatening to get you deported? If they're doing that, it is abusive. They're not supposed to be doing that. They may be doing this for certain reasons. But at the end of the day, there is relief in some situations. I'm going to talk about those situations where you can still go ahead and get your own relief if you are facing a situation like this where a relative or a spouse is threatening to get you deported. Usually, when I see situations like this, it's an immigrant who either you have a visa, you may have overstayed your visa, or you're here without status, or you have your green card, and you have a relative or a spouse who is trying to scare you. They're trying to control you, and they use this as a tactic. They use the threat of deportation to keep you compliant with what they want you to do. So I'm here to tell you that they're not supposed to be doing that, and there are ways to still get relief. Now, I'm going to get one thing out of the way. If you have a 10-year green card already, you're already a permanent resident, and you have someone who is doing this to you, just know that a relative or a spouse, they don't have the power to just get you sent home like that. Now, it's not to say that they can't make your life miserable by framing you or by calling and reporting you to immigration or the police. Unfortunately, people are capable of doing that. But if they're saying, and you should take measures to protect yourself in cases like this. It may not necessarily involve immigration, but it may involve going to the police or seeking advice from a family attorney about how you can attend to those kind of threats. This is if you already have your 10-year green card and you're still or you have an immigration status that you're satisfied with, but you are still facing these kinds of threats, then make sure that you seek either legal advice from an immigration attorney. But if you're not seeking immigration relief, there are other avenues. There's the police if they're threatening to get you deported or threatening harm against you. There's also family law attorneys who can assist you to find civil remedies or a protective order if that's what you need. Now, if you are out of status, or if you have another type of immigration status, but you would like protection from the immigration service, this is what I'm going to address today. Is if this person is using your immigration status against you to keep you compliant by saying that they're going to get you deported, they cannot do that. Only an immigration judge can order you deported. All right. If you're already here, you have to go through a process. So if someone is telling you that they're going to get you on a plane, they're just going to call immigration, call ICE to come pick you up, and you're going to be on your way out of the country in no time, it doesn't exactly work that way. And there is a process that has to happen. For example, if they are going to report you to the immigration, then or ICE, then they're likely going to first look into your matter before they just come and pick you up. And then even if, God forbid, but even if they do give you notification or even come and pick you up, then at that point, you still have to go through a process. They're not just going to take you straight from your home onto a plane and send you out of the country. That's not permissible. You're going to get a notice to appear, get and go through a court process. So if someone is trying to scare you with that tactic, just know that there are hoops that individual has to jump through before they can see you out of the country. But what you need to do though, if you're facing a threat like this, it's not to say you can't do this and don't do anything. What you need to do is make sure you protect yourself first. Make sure that you take the steps to seek immigration relief before that individual can go report you or an investigation can start against you, and then you're now at the disadvantage. So make sure that you seek the immigration relief. And this is what I help clients to do. I do have clients who are in situations like this where they're under threat from a relative, from a spouse, saying that they're going to be deported. And, in cases like this, we make sure that we jump ahead of them to get that immigration relief, to show that you're the victim here and they are not the ones that are telling the truth. You're the victim of abuse. So, my advice here is, if you're going through this, one, make sure you get legal advice, because I'm going to go over some scenarios. I'm going to go over some forms of relief that may be available. But whether you qualify for this is ultimately going to come down to that consultation. Right. And then, two, as soon as you know that you qualify for relief based on threats like this, you jump on it. You be a proactive and make sure you get that relief. So the first is, if you have a relative or a spouse who's threatening you, and that relative or spouse is either your US citizen or resident spouse, or they are your US citizen or resident parent, or they are your US citizen son or daughter who's age 21 and up, and they're using these tactics against you to keep you compliant with them. They're being really abusive, or they're mistreating you. They are subjecting you to extreme cruelty when they're subjecting you to threats like this. Then you know that you can qualify for VAWA. VAWA is going to be the route that you can take to make sure that you gain a sort of protection, meaning that once you apply for VAWA, and even if that spouse or that relative now tries to come with information against you, it's not going to stop the USCIS, of course, from investigating or inquiring into it, but they have to think twice about whether that information can be used against you. They're not supposed to use that information to make a decision on the VAWA, right? And so that means that it puts you at an advantage. It gives you a plus in this process. And you should be doing that before they take action against you, so that you get your story in front of the immigration service before that individual who is mistreating you or who's subjecting you to extreme cruelty. You want to make sure that you jump on it. So I would say, at this point, where you have a relative or a spouse who they are actively they're threatening, and once they're threatening, they're more than likely to be capable of doing worse to you. So they're threatening to get you deported or threatening to harm you in some way. Take action. It is well worth it to make sure that because this is what the immigration service is well aware of. They are well aware of the fact that individuals are being abused based on threats like this. It is now in the policy manual that the officers need to look out for threats like this, that where you have been subjected to extreme cruelty or mistreatment because of threats like this. So it qualifies you to get that relief you need, that protection from deportation. So that's the first thing. Now, what if this person, this relative or this spouse, they are not necessarily, they're not US citizens or residents, or say this individual who is a spouse, or you look at them more as a partner. They're not necessarily your spouse, but maybe a partner or intimate partner. What if they're the ones that are threatening you and you don't qualify for VAWA? What I want to say here is that when I see situations like this where there is clearly abuse or mistreatment, then I delve further into your situation to determine what's the purpose of this threat. Is it to make you compliant, to force you to do things against your will? And despite the immigration status of this relative. It could be a cousin, could be an uncle, could be a brother, could be some distant relative, could be a grandparent. If or with a spouse, or it could be someone who's not necessarily a spouse but an intimate partner, or even if it's a spouse but the spouse is not a permanent resident or a citizen, and they're subjecting you to threats like this, there are other options such as the T status or even the U visa if you have been the victim of domestic violence. So when I talk about T status, it's for victims of trafficking, because believe it or not, this is how individuals do get trafficked as well. So you find yourself in this situation where you may not have legal immigration status, and then you are at the mercy of this individual who is now telling you that you do this, you do the work in the house, or you do what I need you to do. You make sure you have sexual relations with me, or you make sure that you do this work or go work for these people for me and give me your wages, for example, or you have to do all of these things for free. If they're using this threat of deportation to get you to do things like this for them, then that is trafficking. No matter, it doesn't matter that they're not tying you down or locking you up in a room. It does not matter. What they are using though is they're using the threat of deportation to keep you restrained, right? So it's not physical restraints, but they are restraining you by using coercion. So on in the immigration policy manual, they do consider that as an element of trafficking, where the trafficker or the individual, the relative or the spouse in this case, they're using this threat to restrain you. So you're under threat of harm, and because of that, you stay compliant with this person. So if you're facing threats like this, and even if this person isn't a US citizen or a legal permanent resident, even if you're not legally married to them, even if they're not your parent or your adult child, but they're a cousin, they're an uncle, they're an aunt, they're a stranger, they're an acquaintance, maybe even, but I'm focusing on relatives in this live. There is immigration relief based on what the elements that I just talked to you about. You should get legal advice for me to evaluate your circumstances, and then we get started right away, because this is a potential solution. And now is the time to apply for this, because they have changed the USCIS policy manual to include situations like this, where it's not necessarily just by physical force, but where they use these kinds of threats to keep you under their control. So you can always go ahead, get in touch with me, schedule an appointment. You can do that by on YouTube and on Twitch and on Facebook. Going to the description in the video, you'll see the link. Click on the link and it's going to take you to a website where you can go to the official firm website, ST Law's website. You will, on that website, you'll see the phone number, you'll see the contact form, you'll see online chat. You can choose any one of those options, and it's going to lead you to the scheduling coordinator, who will be more than happy to help you schedule your appointment. But say you don't have the time to call right now, you just want to schedule your appointment, go to the link in the profile and you'll see a button right at the top that says schedule your own consultation. Click on that. It will walk you quickly through the form, and you'll be on my schedule in no time for us to talk about your situation and get started right away. So my whole thing is that if this person is doing this to you, they could be, while they do not have the power to get you deported right away, it doesn't mean that they can't report you, and then eventually it can lead to you being detained or sent out of the country after going through a deportation process. So what I would say now is treat it with urgency. Make sure that you beat them to anything by seeking relief from the immigration service, so that they understand you're going through this before they beat you to it. that they understand that you're going through this and you need separate immigration relief. Now, when it comes on to VAWA, where you're being mistreated by a U.S. citizen or legal permanent resident spouse, a parent, or an adult child, you are able to apply for your work permit. You're going to get special VAWA status upon approval, and you will then move on to get permanent residence. You'll get a 10-year permanent residence as soon as you're approved for that permanent residence. And throughout the process, it's about 2.5 years, about 6 months into the process to a year into the process, you are able to get your work permit, your social security number, that gives you some stability. It gives you some reassurance, gives you some time to breathe while you wait for the rest of your process to go through. Now, when we're talking about being the victim of trafficking, or if you have been the victim of domestic violence and you qualify for the U visa, that's for victims of certain crimes such as domestic violence. In that case, you would get a 4-year status, and you do still have the ability to apply for your green card after you get approved for the U or the T status. And the U or T status allows you to get your 4-year work permit. It also has added benefits. So for VAWA and for the T and the U, your children who are unmarried and under 21 do get to get these statuses with you. So for the VAWA, once you get your permanent residence, if your children are outside of the United States, they will join you here in the United States as long as they're under 21 and unmarried. And if your children are here with you in the United States, you apply for VAWA, they will get permanent residence along with you once they obtain VAWA status with you. So it's an important form of relief, not only for yourself, but for your children, especially if you want to make sure that your children are in a healthy environment away from these kinds of threats. And you want to make sure they're protected. With the T, guess what? There's the added benefit, the T and the U. If you are under 21, your parents get to get status with you, and your sibling who is under 18, who is a minor under 18 and unmarried, gets to get that status. If you're 21 or over, then your spouse and your children get it. Also, if you're under 21, your spouse gets it with you too. So it's not only beneficial to you, but it can also protect your family members as well. So go ahead, schedule an appointment, and we can talk about what you have been through and figure out the best solution for you, because that's what I do. We have obtained approvals for our clients who have been through situations like this, VAWA, the T status, and then with the U. Now, with the U visa, keep in mind that the T status, I'm seeing an average of 9 to 10 months, but I tell my clients to prepare for a maximum of 18 months for this process to be completed. With the U, it's taking over a year to be able to get what's called a bona fide determination status that allows you to get the work permit. But then ultimately, to get the U visa, to get the actual benefit of the U visa, it's taking anywhere from 5 to 7 years to get through that entire process. But with the T, it's taking around 18 months maximum right now. Keep in mind that's an estimate based on my experience. It could always change. On average, though, I'm seeing 9 to 10 months to get a decision on it. It's a valuable form of relief that not a lot of people know about, and even attorneys, even if you've had your situation evaluated by an attorney, not a lot of attorneys are focusing on these forms of relief, and so you may be misinformed, or they may not even have addressed those issues in the consultation. That's the thing with my consultations, is when we're in the consultation, I not only go by the information that you want, or that may call me and you may say, I want this, and you may not qualify for this, but I also evaluate you to determine whether you qualify for other forms of relief that you know nothing about. So go ahead. It's well worth it to do the consultation to discuss your situation and determine whether there's a solution for you, because this is what I do. Now I'm going to questions. So I'm going to go through and answer questions. So go ahead, put those questions in the comments while I'm here. So if my mother is filing for you and she is living in a 1 bedroom, does she have to move into a 2 bedroom before she starts a filing process? So that they don't look at any kind of living arrangements. Um, that has nothing to do with immigration. Um, Keep putting those questions in the comments. I will answer. So I filed I-751 2021 January jointly. I submit all joint bank statements, 3 years joint tax, birth certificate of our son. Still I get an RFE for most evidence. What else do I need to submit? Give me a call at this point where you have submitted all of this information and you have gotten a request for evidence. You should get in touch with me, because if you approach this incorrectly, they can still turn around and deny you. Usually, when it comes on to situations like this, where you have submitting all of these are great, it's great evidence, solid evidence. But what I find is a lot of individuals submit the information in a shabby way, and because of that, they reject the evidence. They turn around and reject all the evidence and say, you have not met the requirement to show the bona fide marriage, even though all of this is solid. So, this is where I always say presentation is everything, because you would think your case is cut and dry, right? You have a son, you have 3 years joint tax, you have your bank statement, but there's something here that they're still questioning. And this is where you get an attorney. You don't do it yourself. And I definitely don't advise individuals in a case where they've gotten a request for evidence like this to do it themselves. Because if you think you have a solid case and I'm looking at this here and it appears as if you did provide everything correctly, something is off here. So give me a call, schedule that appointment, and I will be more than happy to assist you. I did have a situation like this where my clients came to me right away after they got a request for evidence like this. And within 2 weeks, that green card was in the mail for my client. So it's just a matter of presenting the legal arguments that are going to get you your approval quickly. Can you marry a citizen, leave, and then file due to extenuating such circumstances within a 3-year period? So, marriage is a complex thing. And if you left your spouse and then you came back together with your spouse and then filed with your spouse, that's not necessarily going to mean that you are going to have a denial. However, I don't know what the details are here, what are the facts involved, and this is where the consultation is going to be very important. All right, great questions so far. Put those questions in the comments. What happened to the abuser, for example, in the T status? Okay, so the purpose of the immigration service is not, they're not a law enforcement office. So their whole thing is they're not going to investigate the abuser in this case. This is why with T status, there is an element that requires reporting to law enforcement or an agency that can have the power to look into your issue. So, for example, with labor trafficking, I do report to the Department of Labor. And with the Department of Labor, they have a special department that focuses on cases like this, and they determine whether they're going to certify your application. And in some cases, a lot of cases, they don't opt to actually go and investigate the individual. In other cases, the victim of the trafficking has already reported them to law enforcement, and it's just a matter of now submitting this information to the USCIS. But the USCIS is not going to be the agency that's going to do the actual investigation of the abuser. They're looking at the evidence that's in front of them. Um, How for you to get work permit after doing biometrics? Also, I think you're saying how long does it take to get the work permit after doing the biometrics in December? So there's no set formula, there's no accurate timeline, especially when the biometrics is all over the place. And it depends on what type of work permit you're applying for. Because remember, the work permit is issued in all sorts of different scenarios: adjustment of status. I just talked about the T status, the U visa, asylum. So it's going to depend on the case type. So just be a little more specific, and then I can give you an estimate here. My question: do you do asylum cases? Absolutely. I do have asylum cases. I'll be more than happy to evaluate your case and then get started right away. After doing biometrics in December and receive work permit approval letter, how long does it take to get the EAD and um, SSN? So right away. Usually, sometimes the work permit comes even before the approval letter. So if it's a couple weeks since you've gotten the approval letter and no EAD, check with the USCIS to see what's going on. Check if they mailed the card out. Um, Now the SSN, it goes to a separate location. So it goes to the Social Security office, and then they issue the Social Security card. So that can take anywhere from a week to a few weeks after the work permit is issued to get the SSN. If the visitor's visa grants you 6 months, is it possible to file for adjustment of status, even though it's possible for you to overstay by time it comes through? So this is a complex question. Yes, when you do have 6 months and you apply for adjustment of status, you have, in some cases, not every. So, for example, if you are the spouse, immediate relative of a U.S. citizen, immediate relatives of U.S. citizens are the spouse of a citizen, the parent of a citizen, and that citizen is age 21 and up, or the son or daughter of a U.S. citizen who is under 21 and unmarried. If you fall within that category, it doesn't matter that you overstayed your visa. You can still apply for adjustment of status. Granted, you qualify in every other way. Now, when it comes on to being in any other category, then you have to make sure that you submit this adjustment of status application before your 6 months expires. And then you also have to be mindful of other things, of course, like the 90-day rule, where if you file anything within 90 days of entry, then they can presume that you had immigrant intent and charge you with misrepresentation or fraud. So, the timing has to be right. But if you apply before your time expires, um, then you can go through the adjustment of status process, even overstay, go over that time and still be okay and come through with your green card and not face any immigration consequences. So yes, it's possible, but it's complex, and you want to make sure that you understand timing, understand how to approach this, whether you qualify for this, because when you're filing for adjustment of status, and you have to make sure you're filing before your time expires. You also have to make sure that you qualify to apply for adjustment of status, meaning your priority date is current. So that's going to have to be another thing that you have to make sure is happening before you apply. So timing has to be right when you're applying under certain situations with adjustment of status. I have a 10-year visa, but I'm afraid to go back to my country because my lifestyle, because I'm gay. How can I go about that? So give us a call. There's definitely, when you are being targeted based on a particular group that you're a part of, in this case, if you're a part of the LGBTQ community and you're being targeted in your country and you do not have protection in your country from violence, from threats, then this certainly qualifies you for asylum. So go ahead, give me a call, and we can talk about how you qualify. Now, keep in mind also that you have to apply for asylum within 365 days of your entry into the United States, or if you don't meet that deadline, it gets a lot harder to get the asylum. You have to show that there were extraordinary circumstances that caused the delay in applying, or that there are no changes that have occurred that now qualify you for asylum. So get in touch and we can talk about this, and go ahead and apply. I am married and I'm waiting on my 2-year green card. We Because every day and this marriage is going down. Now my wife is verbally abusing me and threatening me that if I leave, she will make life hell. This is what I just talked about, except I'm glad that you brought this up. When you have the 2-year green card, right? There VAWA also protects you. And so, I'm gonna tell you a sad situation that I saw, that I feel like if he came earlier to get assistance, he would have been at an advantage, but now his case has gotten a lot more complex. This individual stayed with the abusive spouse and endured her abuse, even though at any point he could have made, he didn't know at the time, but he could have applied for relief based on the abuse. He stayed with her for years until she turned around and accused him of abusing her to the police. The police were called to the house. That was not the case, but the police were called to the house, and he was the one that ended up being arrested for domestic violence, which is a deportable offense, by the way. And so now she was at an advantage because now she's viewed as the victim in the criminal justice system, which makes it a lot harder to bring a case for VAWA to the immigration service. So it doesn't make his case impossible, but had he beat her to those false accusations, he would have been at an advantage. So when you're in a situation like this, I say treat it with urgency. Make sure that you go ahead and schedule an appointment with me. We can talk about your options and get started right away. Because a person like this who is threatening to make your life hell will do things like this: call the police on you, frame you for things that can make you deportable, and call the police on you, call immigration and claim that you committed fraud. So you want to make sure, can't stress enough, that when you're in a situation like this, get legal advice and get started on your own process. As a 2-year green card holder, you can apply at any time. Since you're going through this, you can apply for your 10-year green card at any time before your 2 years expires. And we have done this for our clients, but you want to make sure you approach this carefully, that you do present a good case, and that's what we do for our clients. Can someone's visa be canceled upon arrival at the airport and still be given the opportunity to stay in the country? So usually when the visa is canceled, they turn you around at the border. So if they have canceled your visa and then they still let you in, it may be for other purposes. It may be because that individual claimed asylum at the border and now they are putting them through the immigration court process to determine whether they qualify for immigration relief. So in that case where they cancel the visa but they still let them stay, that's possible. Most times, though, where they're canceling the visa, they're probably turning it around. It's called expedited removal, but they do ask you that question if you fear returning to your country, because you're being persecuted or targeted. And in that case, where you do answer it, they put you through a credible fair interview and then put you through to an immigration judge to be able to seek asylum. So that could be a possibility. What do I do? Should I wait or just leave? Now, keep in mind that this is where you schedule the consultation, because I need to speak with you to figure out exactly what's going on. So, schedule that consultation so we can talk more. I don't give specific legal advice on here, and so I can't tell you to take action based on this live. But talk to me in a consultation and we can talk about what you can and can't do. Whenever you're in this situation where you are fearing for your safety and your well being, put your safety first. I wish that this individual who consulted with me did that, because if they did that, put themselves first, they would not have ended up going to jail for a false accusation. So put yourself first. If you feel like you're in harm's way in any way, get out. Make sure you find safety and then get in touch and schedule that consultation, because your safety comes first. And this is how the VAWA is designed. VAWA is designed that if you are facing this, you can still apply for it even after divorce, 2 years, up to 2 years after the divorce. You can apply for relief, or if you're separated, you can apply for relief, because under VAWA, they still want to make sure that you put yourself first and you find safety. Can I seek asylum at the airport? So at the border, yes. So when you are entering the country, you can seek asylum at the border. Now, if you have, say, for example, you do have a visa and you are traveling into the country with the visa, you can always apply for asylum after entering the country, as long as it doesn't pass 365 days after your entry. Of course, you can still qualify. It gets a little harder though. So you don't necessarily have to declare asylum at the airport if you're coming in with a visa. Now, if you're not coming in with any paperwork, or you have even come in with false paperwork and you want to declare asylum now that you have reached the United States, then it is going to be at the border that you're going to do that, which includes the airport. After they update your fingerprint on your work papers, what's the next step? So usually it's going to be possibly the prima facie determination letter, where and there are multiple processes going at the same time, or it could be the work permit. So even if I have my 10-year visa, can I seek asylum? Absolutely, yes. Now, what I would say though is don't take any actions until you get legal advice, by the way. This live is general information. It is not particular legal advice. So, what I'm telling you here is not to go do something without first consulting an immigration attorney, such as myself. You can always click on the link, schedule, and we can talk about your situation. If you get your work papers, does that mean your VAWA case is approved? No. So the purpose of no, there are two cases where you're going to be issued the work permit. The first is while you're waiting for your VAWA and your adjustment of status process to be completed, you get your work permit. And that's just to hold you over until they can make a final decision. Now, the next step is the VAWA approval, which comes at about the 2-year mark. And at that point, when you do get that VAWA approval, they issue the work permit right away, as long as, we specify, of course, in the petition that we want the work permit issued as soon as the approval comes. So then you get a new work permit with the VAWA approval. And then what happens is while you're on the VAWA status, it moves automatically to the adjustmental status, or you're able to apply for adjustmental status upon approval if you haven't applied already. And at that point, you then get your green card afterwards. So the one work permit, if you're applying for work VAWA while you're applying for adjustment of status, that adjustment of status work permit does not mean your case is approved. It doesn't mean you're guaranteed to have an approval. But once you get the VAWA, work permit, it means you've been approved for VAWA, and now it's going to go on to the adjustment of status. Whether you get approved for adjustment of status to get the green card, though, is going to be a separate evaluation based on other criteria like, are you permissible? Do you have a criminal record? Do you have any past immigration violations? Did you have any past actions that disqualify you? That is usually a separate evaluation from VAWA. All right. If you haven't received your work permit through VAWA, is it something to be worried about? Now, VAWA, keep in mind that the work permit comes with the adjustment of status application, and so it doesn't. Now, you're saying you haven't received it yet, but how long have you been waiting? That's the question here. There's the work permit does not mean that you will or will not be approved for VAWA. So if you're waiting for your work permit before the VAWA approval, that's not going to go towards a decision. But how long have you been waiting? Because when it comes on to VAWA, it can take up to a year to get that work permit. So I don't have my 2 year. I'm waiting on it. So schedule that appointment and we can talk. Even if you don't have your green card and you're waiting, you're in the middle of applying, you can apply for VAWA still. So this is where definitely now you know that there are options for you. Take the action to protect yourself and schedule the appointment. Yep. So you must apply for asylum before 1 year, right? Once 1 year comes, then you have to go jump through extra hoops to still qualify for asylum. How long is the medical valid for? I've done mine in November, so it's 2 years now. All right. So absolutely. So we represent clients in all different states. So 50 states and around the globe. So no matter where you are, we can represent you. 10 months and she applied with adjustment of status. So Sophia, I'm sorry. The questions are going by so quickly. I'm not remembering what your original question was. So I think you were waiting on your work permit. So it's been 10 months and you applied with adjustment of status. So no, 10 months is 10 months does not mean that there's something wrong. If you look at the processing time, it's right now, it's a year, maybe even over a year right by now to get the work permit. So I'm seeing anywhere from 6 months to up to a year to get that work permit. All right. Thank you, everyone, for your time today. I really appreciate your time and your questions. I will be back tomorrow at around lunchtime to continue this conversation. Now, if you have a particular issue or matter question about your immigration case, this is where you schedule the personal consultation to get the legal advice. You can go to the link in the profile and you will see everything you need to schedule your own appointment online without even calling, or you can go ahead and call the number. So the number is on the screen on Facebook, on YouTube, and Twitch. And then also on here, if you go to the link in the profile, you can go to the website and you will see everything you need there to get in touch, to talk to the scheduling coordinator who can help you to schedule your appointment. And I'll be more than happy to help you. That's why I'm here. Thank you so much for the love. I appreciate it. I will be back tomorrow. Have a good one, guys. Bye.